This is the Board of Appeals, Thursday, August 6, 2020, taking place as a Zoom meeting. This meeting is being televised by Chelmsford Telemedia and being conducted remotely pursuant to Governor Baker's March 12, 2020 order superseding certain provisions of the Open Meeting Law, General Law 30A, subsection 18, and the Governor's March 15, 2020, in order imposing strict limitations on the number of people that may gather in one place. We're going to start with an administrative issue, 23 7th Lane, Quality Greens Homes. We have someone here that's going to speak for that.
Good evening, Mr. Chair. Melissa Robbins from Duchesne and Farrell's on the line.
Hello, Melissa.
Hi there. Good evening, members of the board. For those of you, I think many of you are familiar with this application. It was actually approved this last December for various variances. There are two lots on the plan. Lot 2 only had frontage relief granted, and Lot 1 had frontage, side yard, and area relief granted. The issue and the reason I'm here this evening is to ask for a minor change in the decision due to a oversight on the developer's behalf. In the decision itself, lot width was not stated. As the board is aware, lot width is measured at the front yard setback and not along the frontage. It's oftentimes identical to the frontage itself, and I think that's probably why it was overlooked in this case. Thank you. Thank you, Colleen. This is the decision that the board granted. All the grounds for variance relief are exactly the same. The lot width is actually shown as insufficient on the plan itself. It's just not stated in the decision as relief granted. The lot width on lot 1, Colleen, do you have the plan?
I'm looking for it right now. I thought I had.
I was looking for that too.
Okay.
I have it open if you guys want me to share it. I think I can share,
Yeah,
right?
that's great.
Oh, no, it says host disabled participant screen sharing. Sorry, I tried.
I can do that for you. Hold on.
Oh, okay.
One second, I'm sorry.
That's okay.
We just get the August 1st agenda.
Yeah, I only have the letter on there.
But can we go back to the agenda for August 12th?
Yeah.
Yeah, I'm looking at all that data on a different computer, so I definitely can't share.
I'm doing the same thing. Plus, I'm technology limited, so I'd ruin the whole meeting if I tried to do anything. I guarantee it.
No hanging up on us.
Colleen, it was in an email from Patricia.
Yeah, and I have it right here. Why can't I find it?
It just won't let you share. Well, in any case, I can describe to the board the lot 1 frontage that was approved was 83.48 feet on lot 1. And the lot width is 83.64 feet. So it's within 0.15 of the frontage that the board had approved. Lot 2 has a frontage of 20 feet as approved by the board, and the lot width is 19.90. So they're almost identical. They're decimals off of each other. So what I'm requesting from the board this evening is just to modify the decision to rectify the oversight to include lot width in the language, as shown on the plan that Colleen will eventually have, and as I just described.
I have it in my hand. I just can't get it up on the screen.
It's in the
It wasn't sent
December
by
note.
you. Who was it sent by? Was it Patricia?
Patricia, yeah.
We kind of want to reword the decision to include width
That's right.
on both lots.
That's right.
So who made the motion? I don't know if that really matters.
It does not
I
matter.
did.
Mr. Chair.
I made the motion for approval.
I think I have to ask if anyone in the audience would like to speak on behalf of this application.
There we go.
There we go.
Hey, you got it.
I found it finally.
So it's hard to see if you're looking with the screen if you're looking with everybody's faces on the right-hand side, it's hard to see the numbers. But you can see, and the engineer, Mr. Brem, I think is actually on the line as well, but he did the math in reverse, which is nice for us non-engineers. So you can see on this lot 2 at the top of the page, it says lot 2, lot width, variance required, relief 130.10, which means that the lot width is 19.9. Okay, the lot frontage, as you can see in the front, says the same thing. Frontage variance required, relief 130 feet. So the actual frontage in reality is 20 feet. That's what the board already approved. If you look down on lot 1, I'm just trying to find the language at the very bottom there in red.
Yeah.
It says lot width variance required, relief 66.36 feet. For those of you that can't do math like me, that means that the actual width is 83.64 feet. And that, again, almost matches the lot frontage that the board approved of 83.48 feet. And again, unless you have an unusually shaped lot, that's typical.
Are you looking for, I'm not quite sure how to go about it. I think I understand what you're asking. Do we make a motion to approve it with the language of the first decision and include the frontage specifically? Is that what you'd like, Melissa?
What I'd like is the board to take a vote that this is a minor change to the decision and to amend the decision to add lot width. The board
For
already
lot
approved
two?
lot frontage.
For
both
lot 1
lots.
and lot 2.
Correct.
So Brian, if I may, all we're looking for is to add simply that word, those words, lot width.
That's correct.
That's it.
The items that are in red on this plan.
Correct.
That's- yeah.
Correct, yep.
So I guess I'd ask for a motion to close the public hearing.
Not a public hearing. It's administrative.
We don't need to go through any of the process.
No.
We need a motion, though, to do it.
Yes.
Okay.
So a motion to
I
amend.
will also add, Brian, that I also received a letter from the state approving Jeffrey Brim's credentials to be the permit puller for the permits being asked for this project.
Okay.
So we need a motion to amend the decision to read lot 1 frontage being 83.48 or 83.64.
No, you don't actually even have to add the measurements. You just have to say
Just-
lot width.
Correct.
Both
Just
of
lot
them-
width.
They both, on both of the variances, Colleen, do you want to go back to the decision just so they can see exactly how it's worded? It's like a grocery list. So
Right.
lot
It was a
1,
very
just
short decision. Brown
Right.
made a motion to approve the variance request for lot 1, reduce lot area, frontage. So why is that it's not enough for you now?
because we need also, it needs to
Oh,
say
width,
lot
yeah.
width, right?
So it should say reduce lot area, frontage, side yard, width,
Right,
and the variance for lot 2, frontage, width,
right. That's
frontage
correct.
and width. Okay.
Yep, that's it.
So that final motion, correct?
Yes.
I can't make a motion, so someone else is gonna have to do.
So I'll make a motion to amend the decision from December to include a variance approval of lot width for lots 1 and 2.
Do I have a
According to the
second?
diagram.
I'll second the motion.
Yep.
And
Nancy?
I'm going to have to poll again, I think. I'm told by Mr. Haverty.
Yes.
So ask Mark if you're in favor of this amendment,
Yes,
and Erin,
Yes.
Steve,
yes.
and I don't think anyone else is sat yet. Am I right there?
Nancy says yes.
Oh, I couldn't find your name. I apologize.
If I'm voting on this one, I don't know. I know we have 6,
You
so.
would be, yeah. And I would also vote in favor of this amendment.
Great. Thank you very much, members of the board. I appreciate that, and I'll work with Colleen at just getting something written up for your next meeting.
I do
Okay.
too. Thank you.
Thank you very much.
Have a good night.
Thank you, you as well.
Okay. Next is a public hearing for 24 Charlemont Court, William Kamendides, for a special permit under 195(8) to construct a new 24 by 30 garage and a mudroom that will not meet the side setback and any other relief that may be deemed necessary. Is someone here to represent Mr. Kamendides?
Meaties.
Colleen?
Yeah, someone's here. Lisa?
Yeah, so Land Tech, our surveyors, are supposed to be here as well to explain the, variance that we're asking for.
Yeah, I'm here.
Oh, okay.
Sorry, I had a hard time connecting. I'm remote, so it didn't connect right away. I apologize.
And if you just give us your name and address for the record, sir.
Yep. Hi. Good evening. My name is Matt Waterman with Land Tech Consultants, and we're here. And I don't know how to pronounce their last name. Bill Kamendides of 24 Charlemont Court. We're here for a variance tonight from the board to request an extension of a non-conforming building on a small sized lot on Charlemont Court. Bill and his wife have been living here for a long time. They've been in the Chelmsford school system for a long time, and their goal was to expand to add a garage with a small breezeway at the end of the existing driveway. Currently, the zoning allows for structures up to 25 feet along the sideline, and they're requesting to extend down to 11.6 feet to accommodate the garage and the entryway. The lot is an undersized lot. It's 22,000, just over 22,000 square foot lot with 100 feet of frontage on Charlemont Court. And they were hoping the improvements would be in general conformance with the standards. I know there's a lot of small lots in the neighborhood. I think there's a lot of setback issues in this part of town just due to the nature of the smaller size lots, the undersized lots. So it was our opinion that the granting the variance wasn't not inconsistent with the neighborhood and the character of the neighborhood just due to the undersized lots. And I know, and Ms. Kamendides, did you have something? I know that you had prepared something as well, because we also submitted letters of support from the abutters to the right of the lot on the right-hand side if you're facing the house from the road, and the abutter on the left-hand side of the lot as you're facing the house. That
Mr.
road in
Lewis?
it. Correct. Or no, McPherson, I believe, and Lewis.
Okay.
Correct.
I think Mr. Lewis would have a lot of weight in this. He has a letter speaking in favor of this. Is that correct?
I believe so. And is that?
There's a letter. We will read it. So that's fine. I just.
Oh,
tried to
I'm
understand
sorry. Go ahead. No, and we'd be happy to answer any questions. And I don't know if the Kamendides want to add anything to the discussion. I know they had prepared a brief statement.
Can you tell me will the shed be removed?
Yes.
Yes, I think it's too close to the back of the structure, so it has to get removed.
Okay. Are there any other questions from the board at this time?
We're looking for a special permit, not a variance though, right?
No, I think it's a variance as read. I don't know.
Yeah,
What's the dimension on the right side? That's what I'm having trouble finding
More than 20.
from the side.
11.6 to the far corner.
What is it?
11.6.
Oh, okay, that's what they're showing there. Okay. Well, yeah, that's why it's a variance, right?
Right. And well, it's a pre-existing non-conforming.
Yeah, right.
The front corner is 24.8 off the side. So that makes it non-conforming. I'd like to defer to Sean, but I think that would be a special permit, even though the wording was for.
Yeah, so the wording comes out as a variance. I think it being a pre-existing non-conforming lot, that absolutely we should be looking at a special permit.
So we have no hardship concerns at this point.
Correct.
Thank you. I'm going to ask if anyone in attendance would like to speak either in favor or in opposition to this application. Hearing none. I think, Colleen, are you able to read the letters that we have on file?
I am. I do not have the ones from the abutters handy here, but we do have, so we have the standard letter from engineering. The proposed addition will be near or possibly over the existing sewer service. Applicant must contact DPW Sewer Division to coordinate any necessary actions to preserve or alter the sewer service. Consideration should be made to install roof drain dry wells or equivalent to infiltrate roof runoff. Erosion control devices must retain the sediment on site. These must be installed prior to any work or demolition. And then we have Board of Health has no comments. We have a letter from Dan Katufis, Fire. Dear board members, this office has reviewed the proposal for the garage addition, excuse me, proposed by William Kamendides at 24 Charlemont Court and finds the following. The applicant shall install a heat detector inside the garage and must install an interconnected and hardwired smoke detector inside the existing home within 20 feet of the doorway from the proposed mudroom. If this home already contains hardwired interconnected smoke detectors, the applicant shall interconnect wired heat detector in the garage to the existing fire warning signal. All smoke detectors and life safety devices shall be installed according to the current building code standards as of the date of this submission. The applicant shall make application to the Fire Prevention Office concurrently with the building permit application for plan review of all proposed renovations. This office would approve this plan with these conditions and respectfully ask the board to use this letter as part of their approval process. That's it.
So, Colleen, this is Bill Kamendides. You have email from Matt Waterman, which contained the supporting letters from neighbors on both sides of us. I could read the one from the Lewises if you'd like.
You go. You can read it yourself. Sure. I'm looking for him now.
Okay.
Yeah, and I was trying to find it too, and I can't find it quickly. I apologize.
I have them.
I'm going to ask you if you're going to speak, if you could just let me know who's who. Just a little confused with that, but who is Bill that's reading the letter?
Bill Kamendides.
This is Bill Kamendides. Bill Kamendides, the applicant.
Okay, thank you, Bill. I got lost there, and it's a little new to me.
Sure thing.
If you have Mr. Lewis's letter, I'd love to hear it.
I do. To the Zoning Board of Appeals, Town of Chelmsford, dear board members, please accept this letter filed to support the Zoning Board of Appeals application filed by Bill and Lisa Kamendides at 24 Charlemont Court. Bill and Lisa have been our neighbors for 24 years. They are great neighbors and friends. They've informed us of their plans. We support their plans. We hereby give notice that we do not grant any right of access or easement or give up any of our property rights for any part of our property. Sincerely, Fred and Kathy Lewis. And it's signed and dated 7/13/2020.
And I do, Mr. Chair, I do have the other letter if you'd like it read.
Yeah, sure, that'd be great.
Dear board members, please accept this letter filed to support the Zoning Board of Appeals application filed by Bill and Lisa Kamendides at 24 Charlemont Court. Bill and Lisa have been our neighbors for 21 years. They are great neighbors and friends. They have informed us of their plans. We support their plan and expect it will increase property values for their lot and the surrounding neighborhood. Sincerely, Steve McPherson and Janet McPherson, both signed.
Excellent. Thank you. I'm going to ask the board again if there are any other questions or concerns.
I just have a couple of other questions. So the special permit is essentially for increasing the nonconformity, in particular on the right-hand side, correct?
That's right.
Correct.
Okay.
This-
And the
correct.
shed that's going to be removed is the one behind the new garage?
Yes, that's right.
But the
Okay, so the
pool
pool
shed
shed is staying.
Correct.
Okay. And the height, because of course I can't see it anyway. What's the height versus the existing two-story dwelling?
I don't have the dimensions for the height yet, but it is going to be, first floor level. We're not building above the garage at all.
Okay, so there's no storage or kind of a big room that's just storage, but it could be used as a room as well with a window and everything?
No, sir.
So Mark, you're probably looking at under what we would allow for a shed, which is about 16.5, 17 feet, no more than that.
Okay. I just can't see it. It's
Technically,
difficult with this.
with our procedure, if they wanted a second floor, other than the lot size issue, there wouldn't be a concern.
Correct. A second floor would be allowed. Correct.
Right. I'm just asking because I'd like to know what's going up.
Yeah, no, I appreciate it. And I guess we really have no purview with the pool shed being very close to that lot line. That's probably not a concern of ours at this time.
No.
So I guess I would ask for a motion to close the public hearing.
I'll make a motion to close the public hearing. This is Mark.
Mark,
Nancy seconds.
Nancy seconds. I'm gonna have to poll again. I apologize. Nancy, Steve, are you wanting to close the public hearing? I think you're muted, Steve. I'm sorry.
I didn't think we had to poll to close the hearing. I thought we had to poll for the vote.
I'm comfortable with that. I'm just trying to follow Mr. Haverty's advice. I'm not sure.
Okay. I approve to close the hearing.
And Jamie?
Mr. Chairman,
There's Paul.
Yes, Mr. Haverty.
I want to clarify, every vote the board takes during the Zoom meeting needs to be done by roll call.
So we're going to continue that route. Okay.
Yes, thank you.
Jamie, could you vote to close the public hearing?
I can. I will vote to close, but as there's being 6, I didn't know if I needed to vote.
Not sure how that would work either. I guess it would be the 5, though.
Because I know either the last agenda item, one has to step, so I'm staying for the last.
Okay, yeah. There's. I'm going to have to recuse at some point, so you may come in very handy. And Erin, are you in favor of closing the public hearing?
Yes.
I think that's everybody. Okay, I also support the motion. The public hearing is closed. And I think we could take this up. Would anyone like to consider a motion?
I'll make a motion to approve a special permit under 195-8 to construct a 25 by 30 foot garage and mudroom that will not meet the side setback at 24 Charlemont Court, including the letters that were read.
Excellent. Do I have a second?
I'll second the motion.
Right, Erin. Mark, are you in favor of the motion?
I am.
Nancy made it. Jamie, are you in? I guess I'm going to go to Steve. Steve, are you in favor of the motion?
I am.
And Brian makes 5, would be in favor of the motion. We have a unanimous opinion here.
Don't you still have to get a vote for Nancy and Erin?
I think so.
Yeah, even though they made the motion, they could not be in favor of it.
Good point. Good point. So Nancy, are you in favor of the motion?
I am.
And Aaron, are you in favor of the motion?
I am.
I'm not sure Aaron's the critical to that, but we'll include everybody. What the heck?
Let's be very thorough.
So now we have a unanimous 5. So the application is approved.
Thank you, everyone.
Unanimously.
Good luck with it.
Thank you.
Yep, thank you very much.
Have a good night.
Take care. All right. Our next hearing is 47 Sleigh Road, Andy and Lori Ricard, for a variance under 195-9 conformity to build a farmer's porch addition that will not meet the front setback and any other relief that may be deemed necessary.
Thank you, Mr. Chairman. This is Gary Baker, in the Neshoba building. I'm here representing the Ricards. The Ricards are also on the meeting if you have questions that I can't answer. The Ricards are seeking relief from the front yard setback requirements of 40 feet. The proposed farmer's porch will infringe on the setback by approximately 2.5 feet. And that's at 37.66. There's no further impact on side yard requirements or other relief necessary.
I'm going to suggest that this is also a special permit, Sean.
Yeah, that's what I was gonna say. Yeah, okay.
Okay.
If I just, Sean, is that correct?
Yes, Brian, that absolutely is, yeah.
Okay,
Looking for special permit.
perfect.
Great, thank you.
We'll be considering this as a special permit.
Okay.
Question from the board regarding this?
Is this, I can't read this number down here. Is this already a non-conforming lot? Is that 27 on the side, on the left side back down there?
Yes, it is. So it's
Yes,
not
that is.
it's not a non-conforming lot, I don't believe, but it does go within the 20% rule that allows us to issue a special permit.
Correct, falls within,
This is about
20%.
They're about 10% shy of the goal, and we to require a variance is 20%. So we can issue
Right.
the special permit based on that.
But it's a non-conforming still, correct, with this side setback over here? I can't,
I think the side setback is 25.
side setback.
That
would be
dotted
25.
line that runs across there, that's the actual setback.
gotcha.
So that
Okay,
2.4 feet would be clear. They're clear of that by 2.4 feet.
Okay.
So it's an existing conforming lot, but we can give them the special permit relief because they're within 20% of the variance requirement.
Mhm.
Are there any questions from the board for Mr. Baker? Seeing none. I'm going to ask if Colleen has any letters that need to be read in with this application.
I do indeed, Mr. Chair. I have a letter from engineering, Christine Papadopoulos. The proposed addition will be near or possibly over the existing sewer service. Applicant must contact the DPW sewer division to coordinate any necessary actions to preserve or alter the sewer service. Erosion control devices must retain the sediment on site. These must be installed prior to any work or demolition. And I do actually have, I added to the agenda, the sewer plan. So Mr. Baker did provide me with that. Board of Health has no comments. And Fire has no comments. That is it, Mr. Chair. You want to see the sewer plan?
I did see it along with the application, but if you want to put it up, that would be fine. I didn't have any problem with it.
So just for the board, Brian, I would like to make note that every permit that goes out like this, we do issue on the permit itself, a stamp with a phone number to call the sewer department, just in case.
Yep.
And I would like to say that I have contacted them. There are already made arrangements for them to flag where it is. And as a matter of fact, the contractor that will be doing the footings actually installed the sewer line, so that would be helpful as well.
Okay, so you'll be going over it, but you're putting the structure on footings, and they would certainly avoid the sewer line with installation.
Correct.
Thank you.
That's not the sewer plan, is it?
Yes, it is. It's the as-built. Right now it is.
I couldn't tell which screen I was sharing.
If you look to the left of the walkway, it continues out. Actually, it doesn't say, but it continues out over the walkway and then turns to the left and follows it over to the left side of the property, which is weird. There must be a
There's a sewer connection there.
a 4x6 boot. Oh, I see. It goes to a 6x6 TY and then continues back to the street connection. I thought that was a property line, but it is not. That's just the actual sewer, of which there are two. That's what's going on there. Okay. So sewer line wraps around the entire house as well as coming out the front, which is probably for a separate bathroom or something. It connects up to a TY. All of this is outside of the scope of the farmer's porch. It's just the passage where it goes across the walkway that would be a concern, but Mr. Baker's aware of it, and I'm sure he knows how to deal with it. So are there any other questions from the audience regarding this application? Hearing none, accept a motion to close the public hearing.
No motion to close.
By Nancy.
Second. By
By
Stephen.
Mark. Oh, by
Stephen.
Steve. Mark? In favor of
Yes.
closing the hearing? Nancy, are you in favor of closing the hearing?
I'm in favor.
Do you have other questions? I'm sorry.
Nope.
And Jamie, are you in favor of closing the hearing?
Yes.
And Erin?
Yes.
I think that's everybody. I am also in favor of closing the hearing. The hearing is closed. It sounds like somebody wants to consider a motion here.
I'll make a motion. This is Mark, to approve the special permit for 47 Sleigh Road for the farmer's porch and addition that will not meet the front setback and all the letters and requirements that were read in.
Do I have a second?
I'll second.
By
Yeah.
Nancy. So Erin, how do you vote on this?
Yes.
To approve?
Yes, approve.
Jamie, how do you vote on this?
I approve.
Steve, how do you vote on this?
I approve.
Mark, how do you vote on this?
Approve.
And Nancy?
Approve.
I also approve. It's unanimous.
I think we had one too many votes, but
We are overvoting, but we're just going with the inclusive nature.
okay.
Only 5 count on this particular application. But we might as well have it.
I can do the board.
Have a good
You're
night.
welcome.
Thank you. Good luck with it.
Thank you.
Oh, boy, Steve. All right, back to reality. Our next hearing is 6 Brittany Lane, Eswar, Subramanian. I'm going to recuse myself from this. I'm going to ask Mark to take over his chair, and I will observe muted.
Okay.
Do you have the Maybe, Colleen, can you read the application?
Do you have to be visually blinded too?
I do. Sunglasses. I don't know what to
Block
do.
your video.
So I can hide and then,
Brian, that's the first time you ever heard that, right? Visually blinded now.
the only time to go.
We can't see you either.
We just text me when you're ready. Is that okay, Colleen?
Sure.
Okay. Good luck. Thank you.
So this is, I'll go ahead and read the legal ad to open the hearing. 6 Brittany Lane, Esquire, Sumerian. Did you already do this, Brian? No, you
No.
for a variance under 195-9 conformity to build a farmer's porch addition that will not meet the front setback and any other relief that be necessary.
Is this a variance or a special permit?
Okay, well,
Oh.
I think it looks like a special permit to me, but is there somebody here to speak on this?
I'm representing myself. My name is Eswar. I'm the owner of the house.
Okay. Is there anything you'd like to add
yeah,
for
so-
this permit to explain, give us a quick overview?
Sure. So we're trying to put a farmer's porch, which is 6.5 feet. And I think the variance is a few inches without the steps. So it's not overly, coming into the variance that needs to be applied. And hence wanted to request the board for us to permit to build this farmer's porch.
Okay, is there anyone in the audience that would like to provide any information either in opposed or to approve this application? Okay, not hearing anything. Do you have letters, Colleen, that you can read in?
I do. I have Center Water District has no concerns and Fire has no concerns. Yep, that was it. That's all I have, Mr. Chair.
Okay, I think Erin brought up a point earlier, and I'll just check back with Sean. Sean, is this a special permit? This is what it looks like.
Yes, absolutely, a special permit.
Okay, I don't know. It seems the computer must be stuck on variance today.
It's that V, it keeps sticking in.
Okay, so this looks like a special permit. Does anybody else have any comments before we make a motion to close? Okay, could I get a motion to close the hearing?
This is Jamie. I make a motion to close the public hearing.
In a second?
Nancy seconds.
Okay. Who do we have left here? Steve?
I approve the motion to close.
Okay, Erin?
I approve the motion to close.
Nancy?
Approve.
Okay, Jamie?
I approve.
And I approve as well. So the public hearing is closed. Do we have a motion can we take this up and get a motion to approve or not on this application?
I'll make a motion to approve the 6 Brittany Lane special permit to build the farmer's porch, including letters read.
Okay, do we have a second?
I second.
Go ahead.
Aaron-
It's
Aaron
yours. You
seconds.
take that one, Nancy.
Okay, who's got this one?
All right, I'll take it. I'll second.
Okay, Nancy has the second. And Jamie, your thoughts on this?
I approve.
Okay, Erin?
I approve.
Steve?
I approve.
And who else we have?
Nancy.
Nancy?
I
Nancy?
approve. Yep,
I
I
know.
approve.
You already made the motion, but okay. And I approve as well. So I think it's unanimous.
Yep. Good luck
Okay.
with it.
Thank you very much. Appreciate the
Enjoy.
board's time on this. Thank you. Bye-bye.
No problem. I can get Brian back from his vacation.
You bet.
Welcome back, Brian.
Text you.
Get to work.
Probably didn't have time to get a drink of water. Excuse me.
Let me get the agenda back up for you.
Yep, I got Kidder.
So, and this, so we have the two Kidder. I'm not sure how the board or Paul Haverty will suggest handling this. Paul, you want to?
Mr. Chairman, the next two items on the agenda arise from appeals of the same decision of the building commissioner. I think it makes sense to open both hearings and then hear them simultaneously.
Mr. Chair, can we just determine what the voting need or personnel is so there's no confusion? It just seems like this can be a very detailed situation, what's going on with this. I just want to make sure who needs to vote on this, or what is the need for voting, with it being an administrative appeal?
It's an appeal of the decision of the building inspector. I believe that is an administrative appeal. I think we need a vote of 5 to do that, which would be myself, Mark, Steve, Nancy, and Erin.
Okay.
Are you sure?
Is that,
Would it not knock me out as an associate member of the board?
No, that's why you're here.
Oh, okay.
No, that definitely doesn't.
right, that would be 5. Brian, Mark, Nancy, Erin, and Steve.
Okay.
So Jamie, if you'd like to continue, you can. It threatens to be long. And I think this is the last one of the evening, if I'm not mistaken. We have minutes after that.
Okay, no, I'm interested. So I just wanted to make sure voting wise what you need from me. So
Yeah, it will be a little interesting from the sound of it. So that's
yes,
good.
it will be.
So I am going to open both 12 Kidder Road, John Bacchini, for an administrative appeal to the Chelmsford Zoning Board of Appeals pertaining to the decision by the building inspector dated June 19th, 2020 for 12 Kidder Road in Chelmsford. I'm also going to open the 12 Kidder Road, John Bacchini, for administrative appeal to the Chelmsford Zoning Board of Appeals. The applicant seeks to modify the June 19th, 2020 building inspector decision to determine the tolling of applications, special permit, and site plan approvals continues until a final judgment in Hyder et Uxbridge Loop Real Estate Corp. Docket number 1881 CV 02240, Middlesex Superior Court. And I am going to ask, I think I'm going to ask one of the attorneys. I think that Mr. Hausler is actually filing the appeal. If he's available. Is he with us, Mr. Hausler? Are you there? Is Mr. Hausler in attendance this evening?
Looks like he's
I am.
muted.
Yep, here's so.
Can you- Is I think we should try to reach Mr. Hausler.
I'm trying to get.
He
Someone
unmuted.
have his cell?
Hello?
Mr. Nicosia, do you have his cell phone?
Doug Hauser appears to be online. I see his name.
Okay, so that's good.
Sorry, I'm late. Coming over from a different meeting.
I'm typing him privately, asking if he is having technical troubles.
I think he just unmuted himself.
Hello?
Mr. Hausler?
Yes.
He just answered.
Can hear him. Oh,
There
no.
he is.
Hi, you had to unmute me, Brian.
I don't have those buttons, but we can yell at Colleen for that, for sure.
Thank you, Colleen.
Good to see you, Doug.
Good evening, ladies and gentlemen. Can I address the first of the two appeals that are on the agenda?
Yes.
The first one was filed by my office on behalf of the Hyder family, who are direct abutters to the 12 Kidder Road property. I want to begin with some background here of where this is all coming from, what this is all about. The planning board was asked at a hearing almost a year or plus ago, almost 2 years ago. They were given a request by Mr. Bikini to extend the life of a special permit that was going to lapse. The argument that was presented before the planning board at that point in time by Mr. Bikini was that he had been misled or given erroneous information by the planning office, by Evan, a human error, and that he didn't file in time, and the permit actually lapsed. That was the position that was argued that evening. In addition, Mr. Bikini made other arguments that have since been further amplified by various filings that you now have before the board tonight. I want to start off with the very basic premise. The planning board, an elected board of your town, a peer board, voted unanimously 7-0 to deny the extension. That's not something that should be taken very lightly. Because one of the arguments that have been asserted in Mr. Nicoja's letter representing the property owner of Mr. Bikini, he says there's a big public interest issue here. And I think there is. His argument for public interest is that if you don't agree with, support the decision by Sean, that the public interest is not going to be served because we're going to miss out on new revenue and economic development, which is also consistent with some of the other abutter support letters that were put before the board. I would suggest to you that the more important public interest is, does the Zoning Board of Appeals board support a unanimous 7-0 vote of the planning board, who heard almost these exact same arguments? So when it comes to public interest, are we going to put a private interest over that of a unanimous public board? That's the public interest I think you need to consider here. A couple other things to put into perspective. Mr. Nicoja wrote in a letter that the burden was on the Hiders to object to the location of the fence between the property lines of the Hiders on the eastern side of the Hyder property and the western side of Mr. Bikini's property. That, in fact, isn't correct. The Hiders are not on some obligation to object to the location of the fence or the lines during the planning board processes of special permits. The boundary line is a boundary line. The boundary line is not determined by the planning board. And I find it absolutely ludicrous at best, and frivolous more likely, that anybody who's building a fence would build it to the exact quarter-inch of the lot line, which prevents the person putting up the fence from being able to go on the opposite side of the fence to take care of it and maintain it during its life. So all these arguments of hardship and how the Hiders have held up this development from going forward is an absolute 100% falsehood. All the Hiders asked for, and why they did not appeal the decision, was because the planning board had written in condition number 7, prior to the commencement of land disturbance or construction, Loop was to install a fence. That's a pretty simple thing to have to comply with. But Mr. Bikini has a long history with Chelmsford of not liking what Chelmsford asked him to do. Because we had the appeal for about 8 years of what took place on Hillside Gardens, in which he lost not once, but twice, costing the town and an abutter a lot of money in the process. So like a child, he stamps his feet until he gets his way. Well, that's not what happens in public hearings about land use. The land use had a very simple covenant. Don't do anything on the land about land disturbance until the fence is up. Instead, Mr. Bikini had bulldozers clear the land right up to the stone boundary wall of the Hyder's property. And as we've alleged in court, they actually removed or moved stones on that boundary wall. All of this could have been averted if they had simply agreed to move the fence in about 2 feet. They would not have cut trees, which is one of our complaints. They would have not removed brush and plants that had been there for years by the Hyders. They wouldn't have had, if the fence had been installed properly, they wouldn't have had the dust and the commotion that was supposed to be avoided precisely because of the condition that the planning board put in. And yet, instead, unannounced, bulldozers came into the site and did all this work. And they clear cut right literally to the last inch, and as we've said, over the boundary line. So that's what this is all about. This is about an applicant who got a special permit, was asked to comply with certain conditions, and just didn't want to do it. Now, a couple other errors that are in the papers that were submitted to you by the attorneys for the applicant, for the owner of the property, Mr. Bikini. He states that the Hyders can't produce evidence to contradict the accuracy of Loop's property boundary line. And that's in Mr. Nicosio's letter of page 3. Well, I got to tell you something, that's an absolute falsehood. And I'm a little disappointed in Mr. Nicosia personally and as a lawyer, because he's much better than that. He's much more thorough. Because if all he had to do was confer with the legal counsel, not one, but two, that are representing Mr. Bikini in the Superior Court case, and he would have been well aware that Bert Hamill, who is a surveyor and engineer who's been before this board for decades, is the expert for the Hyders, who has put forth evidence and has been disclosed as an expert to the Middlesex Superior Court, and who is the Hyders' evidence, among other things, with Mr. Hyder about where the boundary line is. So that statement, which is a statement of fact, not a legal opinion, a statement of fact, is absolute falsehood. And you should disregard that letter because there are other similar mischaracterizations at best. The stipulation that upon which they were hanging their argument also was nothing prevented Loop from moving the fence, they were not allowed to put the fence up because of the stipulation. That because we asked and reached an injunction, we asked for an injunction, we reached a stipulation, so we did not have to argue this before the court, that the fence not go up exactly where they were going to put it. That has become instead for Mr. Bikini a crutch to say, I can't go forward. Nothing could be more from the truth. All he had to do was move the fence back 2 feet, put up his fence 6 feet high, which he's required to do. He wouldn't have had to touch the wall. He wouldn't have had to cut the Hyders' trees. He would not have had to cut their brush. And instead, because he didn't do any of those things, he forced the Hyders to bring a suit. Remind you now, the Hyders did not appeal the original permit because they thought the condition would satisfy their needs. They weren't thrilled with it, but they didn't appeal it. And because they didn't appeal it, now it's being twisted that they somehow waived their rights. I'm at a loss on this one, folks. I got to be honest. Between a planning board vote of 7-0, evidence by an expert on behalf of the Hyders, who says that the boundary line is where they say it is, so it is at best disputed. It's certainly not an uncontested without evidence issue. And a misquote of the effect of the stipulation, there was no reason for the building commissioner to have to get involved in any of this. The building commissioner said Evan's decision or misinformation, if that's what it is not a basis upon which to extend the special permit. And I agree with him on that. And that was the argument, and that argument is conceded in Sean's letter. So I don't know why Sean now takes the position, other than, there was a lawsuit filed by Bikini against the town. And this was probably the easy way out for the town to get out of the litigation. Well, all it's going to do is force the hiders to sue the town if this board doesn't give the hiders the relief that they're seeking. All that had to be done here is simply follow the conditions in the original permit. They didn't do it timely. There's no fault but on their own. They sat on their hands, and in the interim, they've created all sorts of disturbance and hardship for the hiders. And they've done everything humanly possible to make the litigation as costly, as expensive, and as emotionally distressing as you could possibly imagine on them. I think it's about time that the public interest does get served, that the commission decision, the building commissioner's decision get reversed. There's nothing that prevented the applicant from timely commencing construction, taking the steps necessary if he was really serious about going ahead with construction. And the practical effect of this, and this is the real reason why we're here tonight, is because the lawsuit between the hiders and Bikini is largely affected by what your vote might be tonight. Because even if Mr. Bikini is successful in the Superior Court and after an appeal, if we lose, which could be several years from now, even if that's so, if the permit has lapsed, he would have to go back before the planning board and he would have to get the project reapproved. Now, why he doesn't want to do that is fairly simple. As the minutes of the planning board showed, and this is one of the reasons why I believe they voted 7-0, is because a very important condition that was discussed at length in the planning board minutes didn't make its way into the decision. And that was that there was to be no removal of stone walls, and that there was the stone walls were to be intact, including the one on the driveway and including the one on the east boundary wall. That condition did not make its way into the special permit. And that is, if in fact the board determines that the building commissioner's ruling is incorrect and upholds the planning board's desire, it would force the Bikinis to come back. The conditions that the planning board really intended to put in the decision could be put in, and it would probably lead to a result of a settlement of a litigation as a practical matter. I'm asking this board to be practical. I'm asking it to be supportive of another board's unanimous decision. I don't believe Mr. Shanahan's letter is a valid enough basis upon which to have reversed the planning board's decision, essentially, in practical effect. I think it was written primarily probably by town council to assist in getting a resolution of the lawsuit that existed by the Bikinis against the town. And I think this is time for the Zoning Board of Appeals to do some justice for the hiders. And that I'll be quiet and listen to your thoughts and answer your questions.
So I think you've addressed both of the administrative appeals.
Yes.
We're going to talk with Mr. Nicosa, if you're available, sir, and we'd like to hear what you have to say.
Yes, thank you, Mr. Chairman, members of the board. Always a pleasure to hear from Attorney Hausler, my good friend. I appreciate your zealous advocacy, even if it's run amok a little bit tonight, but that's fine. Let's clarify what history is, first of all. History is that the planning board originally approved this project 7-0 unanimously. It's something that they wanted to see happen. It's a great economic development project for the town. It's good tax revenue. Let me also correct a statement from Attorney Hausler, because I know he wasn't part of the planning board litigation, which recently concluded. And Attorney Haverty can certainly concur on this point. There was no binding declaration or a binding vote or a binding finding that the planning board voted down an extension of the special permit 7-0, as Attorney Hausler indicates. If you look at the exact decision from Judge Bay, which is part of your administrative record, that is not what happened. As a matter of fact, it was viewed that that meeting was merely a meeting to discuss endorsement of Mylars, and it was stipulated as part of the arguments in that case that there was no binding decision on an extension of the special permits. So to say that, or to imply that any action you take tonight steps on the toes of the planning board is a legal and factual false statement. So I think that's an important point to make. Now, a lot of what Attorney Hausler has said is not really relevant. You have a very narrow issue in front of you tonight. The building inspector has made a decision that the Hyder lawsuit triggered tolling of these special permits. And his mindset is that, the Hyders filed an action that prevented the applicant from satisfying those special conditions, which was installation of the fence and related site work to that fence. And if they were going to have to move that fence, that would be an impediment to the applicant getting a building permit at that time, because they would have to go into the planning board and request and receive an extension. So he deemed that the permits were tolled. I agree fundamentally with the building inspector's decision that that event kicked off tolling of these permits. However, I think the building inspector should have gone further and not tied the expiration of the tolling period to when the planning board acknowledged in open meeting in September of 19 that they would be amenable to a request from the applicant to move the fence, amend the permit, and allow them to go forward. Now, understand what Attorney Hausler's clients are asking you to do, or asking what they want. They wanted a fence. The fence got incorporated into a special permit condition that had to be accomplished prior to advancing the project any further. Then they filed the lawsuit to stop installation of the fence. And they now want to argue that because we didn't take advantage of our permits because of this lawsuit, that the statute of limitations for our permits have expired. That's a tad hypocritical, a tad unfair. You don't get to get the benefit of, unclean hands that the Hyders have here. That's a problem. Now, it's an important fact that the Hyders didn't appeal the original planning board approval. And the reason why I say that now is Attorney Hausler spent a fair amount of time tonight arguing over how ridiculous of a location this fence is in terms of its proximity to the property line. The fence was shown on the plan set that was in front of the planning board at the time. The Hyders actively participated in all of the public hearings. The Hyders went on the site walk that took place in connection with the public hearings. The Hyders made no objections whatsoever to the location of that fence or the site work which the Bikinis undertook to install that fence, which is the subject apparently of this private lawsuit. They raised no objections about location or methodology of installation of that fence whatsoever during the public hearing process. And then to compound that problem, they didn't exhaust their administrative remedies and they didn't appeal the matter. That is a big factor that the board should consider. Now, with all due respect to Attorney Hausler's arguments that there is a dearth of merit in the private litigation case, I've seen the deeds to the properties. They have matching legal descriptions in terms of meets and bounds at this property line. So I don't know where these facts are coming from to dispute where the line is. Now look at, the building inspector took the position that the lawsuit frustrated my client or prevented my client's use of the permits. However, the filing of the lawsuit alone is not the most important issue as part of that litigation. If you look at the injunction order of the court in that case, that's part of your administrative record as well. The injunction order that was issued by the judge has the breadth of, you are not to work in this area or put this fence up, essentially. You can look at the exact language. I gave you the exact language, but it's pretty broad, such that from my perspective, even if the applicant now wanted to go back today and ask the planning board for relief from that condition to move the fence, it is at odds with the breadth of the current injunction language in that case. We are prevented by court order from even attempting that. So from that vantage point, the tolling period really needs to be tied to the conclusion of the litigation. Until this property line issue is resolved, nobody knows where the appropriate place is for this particular fence. Now, what Attorney Hausler is advocating is, hey, my clients are acting like children. This is a small issue. Move the fence and move forward with your project. Well, effectively, what he's asking us to do is concede the lawsuit, give up the use of our land without compensation or without adjudication on the merits, move the fence, preventing us from using that portion of the land, and you can move forward. Why in the world should a private landowner be required to give up 1 inch of his land to take advantage of the permits that were granted, which showed the fence in a particular location, gave that land for the usage as part of my client's project? We shouldn't be forced to concede the point just to take advantage of our permits. Completely unfair. It's an unlawful land taking. It's not something that we're willing to do. And again, this dovetails into the reasons on why the tolling has to continue until these issues are resolved. Now, the reason why Attorney Hausler sought an injunction in the first place is he didn't want the fence put in or the work to continue over there until the private land rights issue was adjudicated between the parties. The same analysis applies to us being able to use our permits. Until these issues are adjudicated by the court in that case, we can't effectively use our permit to move forward. Again, remember, special permit conditions 5 and 7 say you can't do anything else on the rest of your project until this issue is resolved. So it may seem small on its face, but it's big in terms of what its practical impact is. That's really what this case comes down to. The stuff about Evan Belansky or the stuff about some of these other issues that Doug is raising is really effectively irrelevant, because it really comes down to, we have a permit condition. We're prevented from advancing the permit because we can't comply with the condition. The hiders caused that event by filing suit. There's an injunction order now that prevents that from going forward. And we shouldn't have to concede, just like Attorney Hausler said, that this case has impacts on the private litigation. Similarly, it would have impacts for us. We shouldn't have to just simply concede the hider's viewpoint of where the boundary line is and the methodology of the work and the placement of the fence to satisfy the demands of the hiders, or be deprived of the use of our permits. It makes no sense, and it is completely unfair. And I think the building inspector recognized that. However, I think it should be taken beyond that again. So you have letters from abutters, 2 of which are immediate abutters that support the project. You have another letter from a business that is looking for space. The public interest here is in keeping these permits alive so that a great new economic development project can continue in this town. The public interest is not served in trying to overturn the building inspector's ruling to kill the project. Now, we have some other tolling considerations that are in play here too, and I've talked to Attorney Haverty about these. The governor's state of the emergency order and the SJC's order affect tolling in this as well. Now, the building inspector took the position that tolling ended at a certain point in time in his letter. These state of emergency orders have affected that and have stopped the expiration of the tolling. And from my perspective, that order, at least on this type of permit, is still in existence. So tolling is going to extend beyond that. I'm sure Attorney Haverty can weigh in on that point as well. This is pretty well briefed. You have the hearing memorandum from me. You've got all these documents in front of me. Set aside the Hatfield and McCoy component of this, okay, between the hiders and the bikinis. Set that aside and focus on the issue at hand. The building inspector made a very narrow finding on tolling tied to litigation. I'm asking for an extension of that tolling to the conclusion of the litigation rather than what the building inspector said at the planning board level. Now, I haven't seen any evidence as of record that supports the Hyder's appeal of the tolling decision. I heard the oral arguments made by Attorney Hausler. A large amount of those are not relevant because of the issue that the building inspector ruled upon. And they're not commensurate with the facts and the law. So I guess that's all I'd have to say for now.
Thank you. I do have a couple questions for you. So as far as the litigation goes today, it was dismissed in land court without action. Is that correct?
So the planning board, when the planning board had their meeting, they viewed that situation as a meeting on signing the Mylars. However, in the midst of the meeting, they had a discussion and sort of a polling of the board members over, number one, whether or not they would consider movement of the fence a substantial change, or whether they would embrace that. And number two, whether or not some of these other factors, such as Evan Belansky's involvement, substantial advancement of the permits, there were discussions on those points in that meeting. So we filed an appeal for fear that that meeting would be interpreted as a binding vote on a denial to extend the special permit. So Chelmsford moved to dismiss. Attorney Haverty argued the case for them. And it was still,
I don't mean to interrupt you, but this is not the case in land court that the Hyders have brought against the Loop.
No, I'm talking about the planning board case. Is that what you're asking?
I guess my question was, the land court case is still active, or that has been dismissed and appealed to the Supreme Court. Is that correct?
Mr. Chairman, the other case I believe is in the Superior Court. The land court case was the appeal of the planning board determination.
And that was dismissed.
That was dismissed.
Yes, but the
And
court.
there was a second appeal. Why doesn't the tolling continue through that litigation, I guess is my question.
That litigation is over. And basically what the court said in that decision, okay, was that there was no binding vote taken on the issue of extending the special permits, and that the appropriate course of action for the permit holder was to request an opinion from the building inspector as to whether these permits were still valid. And then if they were denied there, take it up to the zoning board of appeals, and then Judge Vey and the land court would be waiting for the case to come back to him from what he considered to be the appropriate chain of events from the zoning board of appeals.
So there has not been a ruling by the court, but it is inactive. Is that fair to say, Mr. Haverty?
Mr. Chairman, let me try to put it in a perspective. The applicant came to the planning department asking about the status of the special permit and whether or not it had expired. At one point, the community development director had informed them that the special permit had been extended from a 2-year lapse period to a 3-year lapse period upon operation of a change in the statute. However, that was an incorrect determination, although the statute allowed boards and towns to have special permits good for 3 years rather than 2 years. It didn't require it. And the original special permit was only good for 2 years. Chelmsford's bylaws state that special permits shall be good for 2 years. So that special permit remained good for a period of 2 years.
My understanding is Mr. Belansky's inaccuracy doesn't apply here. It's not
correct.
It's not an issue.
You're right. That cannot be the basis for equitable tolling. So what they did was they put onto the planning board's agenda an item asking for a signing of Mylar plans, endorsement of Mylar plans.
Which is the final step.
Not sure what the purpose of doing it that way was, but unfortunately, what they didn't do was submit a formal application to extend their special permit. There was no notice that was provided to abutters. So it was not a public hearing. It was only an administrative action on the planning board's agenda. The planning board did have a rather wide-ranging discussion. During the course of that discussion, the community development director provided his opinion that if the applicant had come to him seeking to move the location of the fence to get it outside of the area that was in dispute in the Superior Court action, that he would not have authorized them to do that and move forward to the building permit stage. He would have required them to go to the planning board and get a formal modification of the plans to move that fence back. And the reasoning for that was because the fence was an important aspect of the decision that was issued by the planning board. That's the reason why they included a condition that said no site work shall commence until the.
Specifically items 7 and 5.
So because the community development director had that level of concern with regards to that particular condition, he informed the planning board that if it had been brought to him to move that he would have instructed the property owner to come to the full planning board and formally request a modification of the plans. The planning board in their hearing indicated that they did not see that as something that would have been a substantial modification of their plans, and that they would have simply informed the community development director to allow it, and that they didn't think that a full hearing was necessary. After the planning board made their decision, and they did actually have a discussion about whether or not any of the equitable tolling provisions would have applied to this, and whether or not the special permit would have lapsed or be valid. But in fact, that they believed that the special permit would have lapsed because the applicant didn't seek to move the location of the fence and commence construction based upon that. The property owner appealed to the land court. At the land court, the town's position was that it was not an appropriate appeal because there had not been a duly noticed public hearing held on an application requesting an extension of the special permit. And that was the relief that the property owner was looking for in their appeal to the land court. They were looking for the land court to make a determination that the special permit was still valid, but there was no such application that was ever actually in front of the planning board.
Because it was an administrative review.
Correct. So being provided that information, the land court instructed that there were two options in which the applicant could take. They could either file a request for an extension of the special permit with the planning board, in which case, as part of that process, the planning board would make a formal determination as to whether or not the special permit had lapsed. Or they could go directly to the building inspector and get a determination from the building inspector as to whether or not the special permit had lapsed. I think understandably, given the position taken by the planning board during their earlier hearing, the property owner instead went directly to the building commissioner. The building commissioner did ask for my assistance in analyzing this. I did not actually instruct him in terms of how to act on this. I did not tell him that there was a way out for him to try to help the town avoid litigation. I simply provided him the factual details of what had occurred at the planning board and what had occurred at the court, and said it was up to him to make a determination based upon his review.
And I'm going to ask the other board members, has everyone had a chance to read a letter from the building inspector regarding this? In the mailings, if someone hasn't seen it, it's worth a read. Has all the board seen this? Colin, would it be possible to put that up on the screen?
Can I just get clarification, because Mr. Harvey, you were coming in broken. So during the administrative review, there was an informal discussion about extending the special permit.
There was an informal discussion about whether or not the special permit had lapsed.
Okay, and the tolling, but it was all informal. There was no vote. There was no actual binding vote or anything.
There was no application before.
Okay.
The planning board for which they could take action.
So they were given two choices on how to rectify that problem, and they chose to go to the building inspector.
Right. So the land court made the determination that there was no appealable decision that had been issued by the planning board, and then instructed the property owner, if you want a determination as to the validity of the special permit, you can take one of two avenues. And those were the two avenues.
And so, okay. And then that's how we got the letters stating the tolling started here and is in the process. So, okay.
So as I understand it, and I've looked at a little of the numbers, so I apologize if they're not accurate, but I believe they are. The decision was written on June 10th, 2016. That begins the clock for a 2-year period. Then on July, I want to be right about this, 26th, suit was filed, which according to Mr. Shanahan would start the tolling or stop the clock for the 2-year period. That was 338 days. So the clock has stopped until, as I understand it, litigation is complete.
So, Mr. Chairman, if I can clarify that, the litigation that was directly preventing the applicant from doing something with this project and acting on the special permit.
Completing item 7 and item 5.
So I think we need to address the other aspect of the decision. So of the determination made by the building commissioner. The building commissioner determined that because the planning board has provided their input, that if the property owner would like to commence construction immediately, they could move the location of the fence and get it outside of the disputed area that's impacted by that litigation, that is Superior Court litigation, right? Once that is done, if they filed that amendment, it would automatically be approved as an insubstantial change by the community development director, because he's already been informed by the planning board that that's how they review this. So that's the other aspect of the building commissioner's determination, is that the clock would then start again upon the fact that the applicant had been informed that there is a way around any obstruction to the commencement of construction. Now, it gets more complicated in that you don't really go from the date that the planning board provided that information, because there was an appeal of that determination. That appeal is concluded. It has been dismissed by the land court. So then you would start again from that date. However, now we have the COVID shutdown and the order from the governor, and that's extending all permits that are in effect as of the date of that shutdown. And I believe that's still in effect. So technically the clock would not yet be running, but it will start running pursuant to the building commissioner's determination once the COVID state of emergency is declared over.
So they did that on September 11th, 2019. They gave them that option to move ahead with a non-substantial change.
They gave that opinion that if they had come in and do that, that they would have been okay with that change.
And then the building inspector's letter became the next appeal. So when was that date?
Building inspector's letter was June 19th, 2020.
So we had the original 338 days, plus I'm just going to suggest that it's 70 days from then. But of those 70, all of those were in the COVID, I'll call it, extension period.
Right, and they would also be extended just by the fact that the building commissioner's determination was appealed as well.
Was appealed, that would automatically. So there's really two reasons for extension. So argumentatively, the 338 days before the lawsuit was originally filed in July of 2017 are the only days that fall under the tolling now.
So far.
Okay, right, correct. I'm just trying to organize my thoughts. I'm going to.
Mr. Chairman?
Yes, sir. This is Doug Hausler.
May I just point out two things for you to consider? We have a lot of timelines being mixed and matched here. So let's just understand the basics, which is the planning board issued a decision in 2016. Everybody agrees that that's what's happened. And everybody agrees that the condition was no land disturbance until the fence is put up. That's the starting point of where things go crazy. all the applicant. It's not the hiders. It's not the town. It's not the building commissioner. It's the applicant, Bikini. All he has to do is follow that condition. But he doesn't. So instead, he comes in with a bulldozer. He rips down any trees that are between him and the hiders. He rips down some of their trees, as we've alleged. He disturbs the boundary wall, which is another condition that was not supposed to be done. And
not to interrupt you, but that was an excluded condition.
Those are things
did
that
not make it into the written decision.
No, those two are in the decision.
Okay.
So that's my question.
If I may finish,
I'm sorry.
Ms. Brown, if I may finish, please, and then I'll listen. I just want to get some points out, and then I'll be quiet again. I promise. The point I'm trying to get at is all of this hazara, this craziness, is because one applicant who was the one asking for the special permit didn't follow the conditions. And if they had followed the conditions, there wouldn't be a Superior Court lawsuit. There wouldn't have been any injunction. There wouldn't be a need for the building commissioner to get involved. There wouldn't be a reason for town council to be involved. So they're coming to you and asking all these boards to reverse things because he just didn't follow some simple, basic conditions. And it's consistent with what he's done in the past. Hillside Gardens speaks volumes on that. 2 appeal court decisions, a trial they lost. So it's his way or the highway. Well, guess what? I'm asking the Zoning Board of Appeals to put an end to this nonsense right now. And all it has to do is say, building commissioner should never have had to get involved. The planning board, whether it took a formal vote or informal vote, what is clear is they clearly discussed, and they were unanimous in that discussion, that they wanted other conditions to be put in to avoid exactly where we are now, which would have forced the parties to get to a settlement of this case. And instead, we have a very deep-pocketed litigant who's going to keep forcing the issue against private homeowners until he gets his way. And I'm asking the board to put some common sense and to support the planning board's decision. It's not more complicated than that. So anything Mr. Nicosia says or town council says, that's great. The practical effects. He who's looking for equity should be doing equity. And that's not what happened here. So you don't have to get caught up in COVID-19 extensions, and you don't have to get caught up in 338 days of how long it took. All they could have done is simply performed as they were required to do. And he didn't do it. And now he's coming back and asking, and got a favorable ruling from the building commissioner and avoided the planning board. Rather than going to the board that should have heard this thing, he went to the building commissioner. And that needs to be understood. And to quote Mr. Nicosia and I think town council, the fence was an important part of the planning board decision. Well, why don't you support that by overturning the building commissioner, preventing this from going forward? And this should hopefully bring people into a room and force resolution rather than litigation. Now I'll be quiet, and I'm sorry, Ms. Brown, for being so abrupt.
Well, I can appreciate your compassion for your client. Mr. Haverty, when an applicant violates the terms of a special permit, what are the ramifications?
Generally, it would be an enforcement action. It could be instituted by the building commissioner as the zoning enforcement officer. I'm sorry, can you hear me?
Yeah, you're coming in and out, so I'm getting half of your words, sorry.
Okay. Generally, it would be an enforcement action that would be initiated by the building commissioner.
So is there an authority in which by violating the terms with evidence provided, the rest of, would it void, in fact, void the rest of the permit?
No, If there was a circumstance in which the planning board wanted to make a determination that a violation of a special permit had occurred and therefore that it should be revoked, that would require a duly noticed public hearing.
And
Right.
has the building commissioner, has there been any action taken in that avenue with regards to the stipulations of 5 and 7?
We should understand, Jamie, that the building inspector is no longer in the employ as of 2016. Sean was not involved with this action, the original action.
And I won't speak for the building commissioner. I don't know that he has ever been asked. There is a process in which a property owner has the right to request zoning enforcement from a building commissioner, from a zoning enforcement officer. I don't know that that process has ever been initiated by any party.
Mr. Chairman, when do you think it's appropriate if I could chime in briefly?
So I can say
I'm gonna
from,
ask the board if there are any other questions from them, and then I'll turn the floor over to you, sir.
I did have one more, I'm sorry. What is the legal requirement for fence placement in regards to the property line?
Zero.
So you can place a fence right on a
Right
property.
on the property line, right?
Much as
So
a driveway.
Okay, okay. And then, and the hiders did do a site walk and saw where the fence, exactly where the fence was going before the plan was approved?
No, that's not.
No, they did not.
They went on the, if I may, they went on the sidewalk. They understood where they thought the property line was, so they didn't anticipate their trees would be cut down or their brushes and shrubs would be cut down or the wall disturbed. So they thought it was on, let's say, the opposite side of the wall. It appears that the line may be literally within the wall itself.
So the site walk did not clearly delineate
Correct.
where the fence was going to be placed.
Exactly, that's correct.
Okay. Sorry.
That's a great point.
If I could, are you able to produce a plot plan that is a discrepancy from Mr. Nicosi's or the applicant? Do we have two dueling plot plans in this?
We have, I don't know.
Does Campbell have a plot plan that varied from Mr. Nicosi's?
We have an expert opinion from Bert Hamill, who said where the discrepancies are in the determination of the line. And it's a question about, I think he uses the word calls. There's a protocol that's followed in land surveying, and he followed a certain protocol. And he said, based on the fact that some of these things have been disturbed now, he has made certain calls based on other indicia of where the line should be. And his opinion is in conflict with the opinion of the Bikini's surveyor. So there are two different perspectives of record in the Superior Court action.
Do we have two certified plot plans?
That I don't know if we've ever done actual plot plans. I can't say.
Could I ask a
Mr.
question?
Chairman,
What was the actual boundary line marked when they went out to do the site walk?
No.
So they were just, in general, looking around?
That's correct.
Okay, so that's not really, okay.
Mr. Chairman, I just want to make clear, it's not the board's role to resolve any boundary line disputes.
I agree.
So you should be focusing on the issue of whether or not the special permit is valid or whether it lapsed.
We don't want to get off track. I appreciate that.
Okay.
Mr. Chairman, my comments relate to some of Attorney Hausel's comments. I think before we navigate into other areas, I'd like to respond to those contemporaneously if I could.
That's fine, so go right ahead.
Okay. Don't fall for Attorney Hausel's theatrics here. There have been no facts established in this hearing. There are no facts established in any administrative record that my client has violated any terms of that special permit. None. There's no enforcement action. There's no complaint letters. There's nothing. You have a private land rights lawsuit that's happening right now over the location of a boundary line. That's what you got right now. So there is no violation. What my client did was presented a plan set, which the hiders could look at, the hiders could have an engineer look at back in 2016, which had engineered specific meets and bounds of where the property line was on their plan set and exact dimensions of where the fence was going to go on that plan set. There was no ambiguity at that hearing. They knew exactly where that fence was going. They may have had their own general thoughts or misconceptions about how it laid out on the ground. But our information that was provided as a matter of record is what the planning board adopted and used to impose that condition. The condition was a specific placement of the fence. And now the hiders don't want it in that place. The hiders don't want the planning board's conditions to be met. The hiders are mandating that the planning board's conditions must be changed. And we must voluntarily concede land use and land ownership so the hiders get their way. I don't care if it's an inch or it's 50 feet. That's not how it works. We have a permit set. It has conditions. The hiders have frustrated us from using that by filing this lawsuit. And now we can't comply with the terms of the special permit and the plan set. We can't apply for a building permit. And that was created by the hiders, not us. We started the site work to put the fence in where it was going to go. And that's the reality of it. Now, the other problem we have is, I'm going to read it verbatim right now from the court's order in the hider case. Bear with me, my eyes are going a little bit, so I'm just going to put my glasses on. Until such time as the court enters a further order or the parties reach an agreement, whichever occurs first, it is stipulated that the defendant, meaning Loop, and all those individuals or entities working on its behalf at Kidder Road project, as set forth in the complaint, shall not install any fence or perform any work along the stone wall eastern boundary and block the driveway wall along the northern boundary separating the parcels of land owned by the parties. That is meant to keep the status quo of the land until such time as the Superior Court judge can hear the facts and resolve who owns what. That same status quo should apply to your determination on tolling, because until we can make a determination as to whether we can satisfy our current planning board condition, the status quo should be maintained until there's adjudication of that line. By the terms of that order, we are unable to go to the planning board right now and ask for a change in moving the fence in an area within that general description. That's the reality of it. Again, it's a narrow issue. Does the hiders lawsuit prevent us from performing the condition? Yes, it does. Does the condition, lack of performance, prevent us from getting a building permit? Yes, it does. So if we have to move the fence, we would have to get relief from the court ordered injunction. We would have to get approval from the planning board, and we would have to concede the case in chief in the hiders private litigation on who owns the land in question without any adjudication on the merits, without any compensation. My clients have hundreds of thousands of dollars into this land for soft costs, land, and legal fees and everything else that's going on in this case. The facts are so strong to not only support the building commissioner's decision, they really mandate that the tolling should continue until the litigation is over. Now, listen, Attorney Housel is trying to say the Loop is trying to make an end run here by going to the building commissioner. No, we're not. We're following Judge Vay's order in the land court case that said an appropriate mechanism to address these issues is to go to the building inspector and then to the zoning board of appeals if need be. That is a land court judge making that call. That is not my clients trying to make an end run. And obviously it would be futile if we went back to the planning board on a tolling issue, because there was discussion at that board that, notwithstanding Evan Belansky's information and notwithstanding everything else that was going on, they didn't find tolling at that time. Right. Which in our view is an inappropriate decision. The facts and law support not only upholding the building inspector's opinion, building commissioner's opinion, but extending it to the conclusion of this case. Don't fall for the theater of Attorney Hausler's arguments. Don't fall for these irrelevant facts that he's putting forth about other projects and what's going on amongst the parties. Until the boundary line's resolved, we can't resolve the special permit condition of where the fence goes. It's just that simple.
Just one question for you, sir. You stated that the court said, or the parties reach an agreement.
Correct.
So in reality, you two could reach an agreement and then go back to the planning board for a modification of the fence placement.
Yeah, and here's the agreement.
Without the, I mean, but I'm just, is that a correct?
That's a true statement, but here's
Okay.
the agreement. Here's the agreement. Attorney Hausler's clients will say, happy to make an agreement for you. Put the fence where we want it. That's the agreement. And we'll allow you to go forward with your permits. Give up your land rights. Give up your land use. No compensation, no adjudication. You just fall on the sword and we'll stop holding your permits hostage because that's what they're doing right now. So it's not fair to say we have to concede on that point and they don't. Why can't the agreement be the fence is going to go exactly where it was stipulated to go when the Hiders saw the plan set and didn't raise a single objection back in 2016? That is a huge issue. All they're doing now is making it an issue as part of this Hatfield and McCoy nonsense going on. But they don't get the benefit to hold us hostage, hold our permits hostage, interfere with the permits, and now argue statute of limitations at the same time. That is the ultimate hypocrisy in terms of making arguments to this board. We don't get to get deprived of our land, deprived of our permits, all at the hands of the Hiders, and have the Zoning Board of Appeals put a stamp on that. Facts and law don't support that.
Well, since I'm not a judge, I can't say the facts and the law support Mr. Nicosia interpretation or mine. I don't wear the robes. So I don't think he should be making that kind of a pronouncement. That's a little bit of overstepping, to put it nicely.
You're not even wearing a tie tonight.
You're damn right.
Can I ask a question? What, if I can ask this, what exactly are the Hiders looking for in land court? I mean, are they looking for like 2 feet just to preserve their wall? Are they looking for significant?
First of all, we're not in land court. We're in Superior Court.
Yeah.
We brought the Superior Court action because my clients have asserted that their trees were cut down. Their brush.
So are they looking for reparations for the damage that was done to their landscaping, or are they looking for the property lines to be moved, or are they looking for the fence to be moved?
We brought all the claims in one shot. That's correct.
And how far are they looking for the fence to be moved? I mean,
we wanted to be where we thought it should have gone to begin with, which wasn't where the applicant was trying to install it, apparently. But more importantly, and it's just common sense, if you have a fence and you want to be able to fix it, repair it, maintain it, you have to have a bit of space on the other side of it so you're not trespassing on another person's property.
I don't think this is for us to determine, Mr. Hauser. We're just going to leave that alone.
Yeah.
Okay.
I think our points, I appreciate it. I'm very curious as
I'm
well.
just kind of curious why it's become such a huge issue if it's a matter of a couple of feet or,
We should probably stick to the things we have to understand is whether we support Sean's letter as being accurate. The final outcome of it is certain to be a page turner, but it's probably not for us to debate.
I would agree.
So on that note, are we just, to break it down to the very bottom, are we just trying to determine if that permit is valid because of the stoppage of time at some point to some other point?
There are 2 administrative appeals going on here. That is one of them, the second one. The first one is a little more lengthy.
Mr. Chairman, what the board needs to determine is first whether or not equitable tolling applied with the filing of that other lawsuit. And if it did, then the second determination is whether or not that equitable tolling ended when the applicant was informed by the planning board that they would allow the fence to be moved and work to commence.
And
or the
were
conclusion.
that the case, we would still also fall under the tolling.
Right, there would be other tolling issues that, you would still have to do that calculation. But first, you need to determine whether or not equitable tolling ever applies.
So let me ask the board, is that a comfortable question you're willing to respond to at this time?
And
Does
that
everyone feel they have enough information to make the decision of, we do know for a fact when the decision was issued. We know when the lawsuit was filed. And my understanding of it is once the lawsuit is filed, they were prohibited from continuing the work. So tolling would begin. That is my opinion, but I don't know if the board is clear on that.
Well, yeah, so that's my opinion also. And if that's the case, they are within that timeline where it would still be valid. Am I right?
You would be agreeing with the decision of the building inspector, which again bears reading. I don't know if you got a chance when Colleen had it up on the thing.
I know, I'd like to see it again.
So it's on the agenda if it's easier for you to print it and just take a peek at it. There's the two choices are there. There it is again. So that is our decision tonight, is whether we agree with the opinion of the building inspector that the tolling did start. That's really the only question, is did the tolling start upon the filing of a lawsuit? Was the filing did stop the applicant from moving ahead, which the argument would be that it was minimally the date that the judge had the finding forbidding the construction of the fence. That would be the very last day that I would say there could be confusion about that.
What was that date?
That's a good question.
Yeah.
Attorney Haverty, do you know the date that the land court planning board case was ended?
I don't think that's what the chairman is asking. I think he's asking when the injunction stipulation was issued in the Superior Court case.
Yes.
That is what I was asking.
August 8th, 2017.
August 8th, yes.
But Mr. Chairman, I would say that if the tolling is applicable, it would have commenced with the filing of the complaint.
That would be the tolling, in your opinion. The tolling.
Yes, we're only talking about a couple of weeks, anyways.
Yeah, I agree. It was.
So that's July 26th.
Yeah, we're 14 days difference. So yeah, July 26th.
If I may recommend, when you are ready, I would suggest closing the first hearing and voting on whether or not the equitable tolling is applicable, and then you can go back and complete discussion on whether or not the equitable tolling ended with the planning board determination, which you will only have to do if you determine that equitable tolling is applicable.
So I'm going to ask the board if they have any further questions of the two attorneys or Ms. Haverty, three attorneys.
I would have a question now. For equitable tolling to be applicable, it would have to begin before the expiration of the permit, whatever the issue is that caused the tolling to start.
That 2-year date.
And that's 2 years from
the 16th of June, 2016. The 10th of June, 2016.
Okay.
So that indeed was the case. They filed suit before the 2-year period had ended.
Okay, so
they filed suit after 338 days.
About a year, yeah, 1 year in.
Okay, so step one is to determine whether or not we agree that the tolling was applicable because the applicant was no longer able to do the work because of some filing
lawsuit.
Or lawsuit court case. That is step one, that we have to get to that decision. Okay.
And we need to close the public hearing. I just want to make sure that everyone has asked the questions of all three attorneys that they need to.
I have.
So the special permit wasn't, and the decisions wasn't rendered on September 14th, 2016? Am I reading that wrong from the?
I think the decision was June 10th, 2016. But I can be corrected, but I believe that was the case.
It was actually September 22nd, 2016.
That's when it was filed with the town clerk.
Yeah, I am reading the certificate of decision right here, and it says the board deliberated and rendered a decision on September 14th of 2016. So is that our date?
That would be the date. I don't know where I got June from.
The applicable date is definitely the date it was filed with the town clerk.
Which is September 22nd, 2000.
The date it was filed with the town clerk, or the date they went
Correct.
to the decision?
No, the date the decision is filed with the town clerk.
Right.
On or about October 1st, we could argue. Unless we have that decision and it's dated. That
I have it. Hold on.
Oh, it's in Sean's letter.
September,
It's
Our
September
filing
22nd.
includes it and it has the
Yeah.
town clerk stamp on it.
September 22nd.
Yeah.
That was the date of granting.
The date it's signed.
I have it as granted.
Clerk.
So the decision has the stamp from the town clerk's office and it's stamped September 22nd, 2016. That is the exact date of the decision. It doesn't matter what the decision itself is dated. Sometimes it gets filed, a couple days after it gets signed.
So then on July 17th, the lawsuit was filed. July 26th.
Of the following year, yeah.
Of the following year.
Yep. So give or take 9 odd months after.
Mr. Chairman, I just want to remind you, you just made a very important comment. It's the equitable tolling. So who's causing these problems? That's what the equitable portion of this comes into play. None of this has a problem. So it's not just a strict application of dates. You have to take into effect the party's actions, conduct, and statements. That's equitable, not just a hard and fast, let's look at a calendar rule.
I agree with Attorney Hausler, and ultimately the issue is the planning board approved the fence in a certain location, and his clients are seeking to force us to put it in a different location. That's the end of the debate.
Are there further questions from the board for the attorneys or for anyone? And this is administrative appeals. Do I need to go into the audience? Is that, I don't believe we have anyone with us tonight anyways, but
There's a
just
few,
want to make sure we do it right.
there's a few people out there. I would open it up to the public.
So if anyone in attendance tonight would like to speak either in favor or in opposition to this administrative appeal, please tell me your name and address and speak. Hearing none. And if the board is satisfied with the questions, we can close the public hearing. I'm not trying to rush things along. If there are further questions, we are here.
Mr. Chairman, I just think you need to clarify which public hearing you're closing because there are two open.
Correct. So we're going to go with the, I lost my,
Second one?
it was the second one in order, yes.
Yeah.
No. I believe it was the first one.
Yeah, the Hyder appeal is the first one.
The Hyder appeal is the first one. So the question is, are you going to overturn the building commissioner's decision?
No, whether
That's the determination that needs to be made before you go to the next.
That's correct.
Second
Correct.
Whether or not it
Correct.
started up again. Because if equitable tolling were applied, then you don't have to get to the issue of whether or not it commenced, recommenced.
Yeah, okay.
So if the board has no further questions, we'll accept a motion to close the public hearing.
I'll make a motion to close the public hearing.
On the high.
I'll second.
Which one?
That was Nancy.
No.
She said, think I heard which one.
are we closing?
Oh, sorry, it was me. I'll
Okay.
make a motion to close the public hearing in regard to the administrative appeal to the Chelmsford Zoning Board of Appeals pertaining to the decision by the building inspector dated June 19th, 2020. That's the right one, right?
The Hyder appeal.
Oh, the Hyder appeal for 12 Kidder Road.
Trying to make
That
this.
cover it.
I second.
Second by Steve. Erin, are you in favor of this?
Of closing the public meeting? Yes, I'm in favor.
Yes. Steve, are you in favor of this?
I am.
Jamie, are you in favor of this?
Yes, I am.
Nancy, are you in favor of this?
Yes.
Mark, are you in favor of this?
Yes.
And Brian, I am also in favor of this. So the public hearing is closed. I suggest we take it up. I don't know what the thinking is. I think that as best I can understand it, once the lawsuit was filed, they were entitled to tolling. That would put the project on hold. Furthering it was the injunction, which is not apparently the point legally. So I just would find it impossible to move ahead with the injunction. Regardless of that, I think that that's my opinion on the matter, and I'd love to hear from all of you.
So
as well.
That's mine also. So based on that, it's my understanding that the building inspector, that it's also his opinion.
I believe
no,
that
this
is
was
the
the
case,
opposite.
yes.
Okay, so we are upholding his opinion and not.
Well, we haven't had
addressing
a
it
motion yet. A motion will be to uphold it, and your
Okay.
vote in favor of that would uphold his opinion.
So
if you
voting yes to the motion would be to uphold his opinion, stating that there is tolling.
As Mr. Haverty said, we should always vote in the affirmative,
Yes, that would be
regardless
the
of the
vote.
actual vote.
Okay,
The motion should be in the affirmative.
yeah.
So the decision has nothing to do with whether or not the litigation has been completed. Right now, we're just determining whether or not tolling was in fact in effect.
Correct.
Correct.
That would be the next thing on the agenda. The
Just
next
how
thing on the
long
agenda.
tolling was for is the next agenda.
Correct.
Okay,
Any other
so
opinions from board members?
making a motion to uphold the building inspector's
And I'm
decision.
going to correct you because I keep doing it myself. The building commissioner.
Yes, okay. Making a motion
I apologize.
to uphold the building commissioner's decision would be a statement that we believe tolling was in effect for this whatever we have going, this issue, and then we'd have to go through and do the math after this to see if it
Determine at what point tolling
expired.
was a factor. Yes.
Okay.
And tolling began the date of the injunction or the date of the filing of the suit of July 26, 2017.
Correct. Yes.
That would be the stance. Okay.
That is supporting the building commissioner's opinion. And he is of that opinion that at 7/26/2017, tolling began.
Okay, so if we're all set with questions, I'll start a motion. Unless anyone else has any more to add or discuss.
No.
Okay.
So, and can I just ask one more question, just so that I make sure that I'm absolutely clear on this? So tolling, basically, the tolling period puts the special permit on pause and further will extend
Puts
it.
the timeline on pause.
Yeah, right.
Yeah, okay. Just want to make sure. The term tolling, I was formerly unfamiliar with, so that's the gist that I'm getting here, but just want to make sure. Thank you.
The expiration date gets pushed off for every day that tolling is in place.
Yeah, okay, yeah, thank you.
Yeah, I had to look it up myself.
Yeah, I'm getting that understanding, but I just wanted to make sure that I have confirmation. Thank you, Brian. Okay.
Learning curve for sure. This
Yeah.
is new, to me, and I think all of us.
I would make a motion to uphold the building commissioner's determination that polling was in effect
7/26/2017.
7/26/2017 for the special permit that was granted for 12 Kidder Road
On 9/22/16.
on 9/22/2016.
Second.
A second by Nancy. I'm gonna poll here. Mark, are you in favor of the, I don't even know what to call it.
Motion.
Motion.
I'll go with motion. Mark, are you in favor of the motion?
Yes.
Erin, are you in favor of the motion?
Oh, sorry. Yes, I'm in favor.
Jamie, are you in favor of the motion?
Yes.
And Steve, are you in favor of the motion?
Yes.
And Nancy, are you in favor of the motion?
And
I am also in favor of the motion. It is unanimous. We are upholding the building inspector's decision that
Commissioners.
building commissioner's letter that says tolling took place starting on 7/26/2017. Now our next task is to decide how long tolling was in place. But as of,
Mr. Chairman, you're returning to the public hearing now on the other application.
so we are back in the public hearing on the second application.
Mr. Chairman, if I may.
Yes, sir.
My request is to extend tolling to coincide with the conclusion of the Hyder's private litigation, because only then will we resolve where the fence can go and, can we address the special permit condition at that time? So until that determination is made, I see no other option. Now, I understand the fact that we can fall on the sword, give up our land rights, beg and plead with the Hyders, and go back to the planning board, concede all of our rights for no money, and move the fence, and they're likely to give that to us. However, we shouldn't be able to do that. So for the same reason the court issued the injunction order, not allowing us to continue with work until the boundary line is resolved, so that the Hyders can know what they have and we know what we have, the same analysis has to apply here for the Hyders to know and us to know what we have in terms of that special permit condition right. It's really as simple as that. And the fact that we were on notice by the planning board that we can move it does nothing to address the concerns that I've raised about having to waive our rights and give up our land. Thank you.
Mr. Hauser, would you like to speak?
I don't, there we are. Thank you for letting me speak. After your last vote, it's just going to make us go to the land or superior court to appeal that decision. So it's kind of a moot issue, but thank you for the opportunity.
Very good. So I think I'm going to ask Mr. Haverty to give us a little primer on the tolling, on how I'm having a hard time understanding what ended the tolling besides the planning board's decision in September 11th, 2019, said that you can come to us and we'll figure it out or something.
No, so Mr. Chairman, to clarify, the position of the Hyders during that meeting with the planning board was that the applicant could simply move the fence however far back necessary to get it outside of the disputed area, and they could commence their construction. the community development director informed the planning board that he would not allow a building permit to issue if they were to move that fence because it would not be consistent with the plans that were approved by the planning board. And it was his determination that that would likely be a major modification requiring a new public hearing for the board to accept it as a change. Because of the condition that was imposed with regards to that specific fence and the timing of when it was supposed to be constructed. It was deemed to be an important condition, and the community development director did not feel comfortable simply unilaterally allowing that fence to be moved. So the building commissioner made the determination based upon that input from the community development director during that administrative meeting that the applicant was unable to obtain a building permit during that period of time simply by coming and providing a set of plans that moved the fence and then obtaining a building permit. However, with the determination made by the planning board that they would not consider that to be substantial, the community development director can now simply accept a set of plans that shows that fence being moved and send it directly to the building inspector for a building permit. So that's why the building commissioner made the determination, if the applicant was so inclined, they could move that fence and currently come into him now and get a building permit. And therefore, that is why the equitable tolling stopped running, or would have stopped running at the time the planning board made that determination. Now, there was an appeal of that determination. Since that time, we've gone into COVID lockdown. So it's not quite as neat and simple as looking at the date of that hearing, the administrative meeting.
And that was September 11th, 19.
Correct. So fortunately, we can't pinpoint it quite with that accuracy.
Oh, okay.
But the underlying
have an appeal filed, which starts the tolling again.
Correct. So we're at no point have they come out of the tolling yet. Because of the COVID, because of the appeal of the determination of the planning board, and then the appeal of the building inspector's determination. This has been in some sort of appeal or COVID lockdown at all points since that September determination.
The clock's not ticking for several reasons.
Correct. And likely if either party takes an appeal of your determination, it won't start ticking immediately. However, that you don't need to make that determination. All you need to do is make a determination that if the applicant chooses to come forward with a revised set of plans, they can obtain a building permit currently. And therefore, if and when no more other tolling issues are applicable, the Hyder lawsuit filed on July 26, 2017 is no longer an obstruction to the applicant obtaining a building permit to construct this project. I did want to address the language of the stipulation that was made into an injunction by the court. It states that the defendant and all those individuals or entities working on its behalf at the Kidder Road project, as set forth in this complaint, shall not install any fence or perform any work along the stone wall eastern boundary and block the driveway wall along the northern boundary, separating the parcels of land owned by the parties. Presumption is if they come in with a new set of plans that shows the relocation of that fence, that it will comply with the express requirements of this injunction, that it is not going to be along the boundary, that it is not going to block the driveway wall. So
that is still in place.
My understanding is that as long as it doesn't do those two things, there would be no violation of the injunction issued by the court. So I don't see that as something that can, would extend the timeline for the tolling. And with regards to the issue of whether or not putting the fence outside of this disputed area would waive any rights that the property owner has with regard to that disputed area, I don't think it does legally waive any rights. I think it's a change of position. I think that, it may be something that they would prefer not to do, but I don't think that it has an actual legal impact of giving up any rights that they have to that area. The litigation would continue. It would continue to a resolution, and upon resolution, that'll be the determination of who owns that property.
So in theory, they could put the fence in outside of which I still have no idea what dimension this is, the disputed area. if they did that and they went through this whole process, it may be that the land court or Superior Court, excuse me, says you can move it. You have to put it here or there or some other place. As long as they are in keeping with the judge's conditions, the fence can move. It's a minimal cost when looking at a 23,000 square foot building. I don't think putting the fence back in would be the worst thing. But they would have to install it to meet item 5 and 7 of the conditions of the planning board. The fence has to go somewhere in order to get the building permit. Is that fair to say?
That is what the special permit states.
And not be in conflict with the judge's ruling.
Correct.
And then they could in sense still continue with their own appeal in land court without jeopardizing their own position and still meet the current injunction from Superior Court and meet the stipulations in the special permit.
Right. The only case that continues to be ongoing is that Superior Court case that was filed on July 26th. The land court case has been dismissed.
And the tolling would apply to that case as well.
Correct.
The tolling was for the land court case.
Well, no, the tolling.
Land court's done.
Termination, the tolling commenced upon the filing of the Superior Court case.
Okay.
The land court appeal was a separate issue, tolling it as well. But that part is over. That case has been dismissed. It's no longer at issue. So the only litigation currently pending is the Superior Court litigation. And again, I don't think that moving the fence changes anybody's position in terms of the legal issues that at play in that Superior Court case.
And when was that decision written that you read where it said, with the court ruling that said?
That was the injunction. That was from August 8th, 2017.
Clear as mud, sir.
Welcome to our world.
So I guess, Mr. Hammond, if you could give us I really don't want to go to your world, Mr. Ngozi. I'm really quite sad at this.
I don't blame
Yeah, it's a difficult situation for a layman to understand. I'm sure it was a challenge for you guys to get through as well. So I guess I'm looking at Mr. Haverty for an idea of how a motion would be worded.
Chairman, I think a motion to uphold the determination of the building commissioner with regards to the recommencement of the lapse period.
And that would be further, would that change? It would change nothing. I mean, it's just saying that his tolling is correct, and whatever happens after that, because of COVID and every other item, is the way it's determined. We don't have to determine that.
Correct. You don't have to calculate the date. All you need to do is uphold the determination of the building commissioner.
We can vote yea or nay to that.
But he's referring to a informal discussion between board members during an administrative appeal, correct?
That is correct.
It's the planning board.
Right, so it wasn't a public hearing to actually affirmatively say, there was no presentation as far as the moving of the fence and approval of a board.
There was no set of plans that was brought to the planning board. The planning board did not review anything, but what the planning board stated was if the applicant provides a set of plans that shows the fence being located right at the edge of the disputed area, rather than what they claim to be the property line, they would consider that to be insubstantial, ministerial, something that could be approved at the staff level, rather than having to the planning.
Okay.
So what was the venue for that? Just a conversation or?
An administrative, it's not a public hearing, so there was no testimony that was acceptable.
It wasn't a matter that was appealable because it wasn't a public hearing. There was no notice provided to abutters. But what did happen during the course of the meeting was that the property owner was informed that they do not need to go for a substantial change to move the fence. They simply need to provide a plan to the community development director, and then he can simply sign off on it administratively, and they can go forward and file a building permit.
And they would install that fence to continue the rest of the project. It would have to
Correct.
be installed.
The linchpin of the entire project is that fence being in place, because the special permit requires it to be in place before they can do any other work, which is
So
why
this would allow them to
equitable
install-
tolling applies, because otherwise, if it was simply a matter of it requiring the installation of the fence, it could wait until the end and they could do the rest of their work. They could have obtained a building permit and tolling would never have been an issue. It's the rest of the work
Correct.
can't
They
go
could
forward.
install the fence, and if they prevail in Superior Court, they could relocate the fence.
Correct.
Now, is there not an injunction stopping them from doing work on that part of the property?
That injunction would be lifted at the end of the Superior Court case.
So they're not putting it where.
Permanently, depending on which party prevails.
Okay, so they could put the fence somewhere else, they just can't put it in that spot?
In that disputed area.
That's how I
Okay.
interpret the injunction.
Yeah, so again, Mr.
The
Chairman,
parties come to an agreement.
so, I mean, therein lies our problem. I mean, why should we have to be forced to concede that point now to get our project to move forward again? Even if, I mean, there's gonna be
Point
some.
of order, Mr. Chairman, point of order. Neither Mr. Nicosia or I should be talking at this point, so.
He hasn't closed the public portion of the hearing yet.
Yes, this is still a public hearing on this.
Okay.
So the one point, I'm gonna ask a rhetorical question and then I'll shut up. What is the harm to everybody involved to continue the tolling until the conclusion of the Hyder litigation? Who is harmed by that? What is the public interest in that? So it certainly doesn't harm the Hyders, because the fence is not going to go in the area that they don't want it to go in, absent us coming to an agreement or getting relief from the injunction order. And it balances the harms because we're not forced to put it in a place that we don't want to put it in. And it also doesn't have to go into a place where the planning board already approved it. So to extend the tolling to coincide with an adjudication of where this property line is, how does that hurt anybody? It doesn't.
But you won't be able to move ahead.
Well, can I ask a question? So if we were to vote against this, what would the process look like for them then? The special permit would effectively be expired and they would have to go back in front of the planning board
We already said that the special permit is not expired.
It's not expired. We had about something like 10 or 11 months, or give or take, before you start factoring in the COVID orders and how that impacted tolling and extended it from there. So we're still in that ballpark of time. But the reality is that the litigation with Hyder may not be adjudicated on the merits during that time period. And then we may run into an actual expiration of the permits if you adopt on its face the building inspector's tolling time period.
Yeah, and then you would have to go in front of the planning board and reapply for another permit.
For a project which was unanimously approved 7-0, is a great project for the town. Why should the applicant be put through that expense again?
Yeah, I just want to understand
I mean, that's the whole point of it. We don't want to have our permits expire during the elongated contest with the Hyders in the private case. That's the issue before you in this particular request. That was likely to happen if you just simply adopt the building inspector's opinion on the tolling calendar dates, even factoring in COVID. You know, I don't know when these orders are going to end, but they could end soon. And I will say this, Superior Court's pretty backed up right now because of the COVID delays. And to get a case through trial in Middlesex Superior Court takes forever anyways. So
why is the tolling not inclusive with Superior Court? Why wouldn't you be able to continue that just by right?
Well, that's what I'm asking. See, the building commissioner's determination was not that. The building commissioner said you were on notice from the planning board that you can move the fence and therefore your project can march forward with that modification. So I am requesting exactly what you just raised as a question, Mr. Chairman, that why shouldn't it continue until the conclusion of the Hyder case? Because if the filing of the Hyder case triggered it, the conclusion of the Hyder case should conclude it in terms of a tolling time period. The only other option is for us to just voluntarily give up our rights, put the fence where the Hyders want it, and then do our project and continue to litigate to try to move the fence back. Like, we shouldn't have to be forced to do that. Same reason why we can't put the fence in now with the injunction order. The Hyders shouldn't have to be forced to allow us to put the fence where we want to put it until their land rights are adjudicated as well. What's good for the goose is good for the gander here. Let's get the property line issue resolved, then start ticking the rest of the time off on the permits. And if in the meantime we come to an agreement, well, that's great. We come to an agreement. But if we don't, I don't have my permits expire in the midst of this ongoing litigation.
Can you get it, is there a process for if special permits do come for up to expire that they can get a request an extension?
So we would have to go in and request an extension. And as has been discussed earlier in the proceedings, when we were in front of them on that administrative hearing, they had a discussion where the planning board was not going to vote in favor of an extension if that were in front of them. So that's our other concern, because that would be a futile effort. All the planning board said that was favorable to us was, we have no problem with you moving the fence and we'll allow you to continue. Well, again, this isn't a one-way street. The land rights case has to be adjudicated before we determine where the fence is going and before our permits expire. That's what the fair, just, and balanced result should be here.
Or perhaps the planning board wanting to get its opportunity to refine its decision or make more clear its decision is being impacted by your decision tonight. The planning board clearly indicated it would have loved to have made more conditions explicit in the decision, which is why the applicant doesn't want to go back before it.
Yeah, and
he wants to extend this as long as he can.
That's a real concern. And you know what? Had you had those concerns back then when the permit was first granted,
I know,
and the planning board had those issues, they shouldn't have voted 7-0 in favor of it, and the Hyder should have appealed, and that didn't happen. So,
Mr. Chairman, I think we're getting pretty far afield here. I want to remind the board that what is in front of you is a request to overturn a determination made by the building commissioner. The building commissioner was asked to review a special permit in the subsequent activities that occurred after the issuance of the special permit to determine whether tolling is applicable. In this instance, the equitable tolling was based upon the filing of a lawsuit in the Superior Court. And what the building commissioner needed to make a determination of was whether or not the filing of that lawsuit prevented the applicant from coming in and obtaining a building permit to commence construction. Because if it didn't prevent them from coming in to obtain a building permit to commence construction, then equitable tolling does not apply and the lapse provision continued to run. The building commissioner made the determination that as of September 2019, the property owner was unable to come into him and obtain a building permit. However, he then made the further determination that enough information was provided to the parties that after September 2019, the applicant could come in and obtain a building permit to commence construction on this project. That's the only thing that the board needs to make a determination. It does not need to weigh the equities. It does not need to make a determination as to whether or not an appeal should have been filed previously or not, or whether or not
days gone by. It just doesn't.
Planning board would grant an extension if requested. I would note that the planning board was not making a determination on whether to grant an extension because that was not requested at that time. The planning board was asked whether or not the permit had lapsed.
the only qualification I make to Paul's statement is that our request is requesting a modification of the building inspector's decision to extend the tolling.
But the building commissioner made a determination that as of that September planning board hearing, leaving aside all of the other tolling issues that have occurred since then, The applicant could come into his office, file a building permit application, receive a building permit, and commence construction without having to go back to the planning board to get a modification of their.
Or be in violation of the injunction.
Correct. So the question is that determination that the applicant could come in and obtain a building permit now the correct determination? That's what the board is being asked to make a decision.
But in order to do that, they have to build a fence. Is that?
That is part of the special permit requirement. Yes, they cannot move forward and start construction on this site with that fence not being constructed. So the question is that it really needed to be determined is, can they build that fence now in an alternate location that would comply with the injunction and that would not require relief from the planning?
Okay.
Would either of the opposing attorneys like to make a final statement before we have a motion to close the public hearing?
I wish you all have a wonderful weekend. That will be the final.
Likewise. That's the one thing we agree upon.
Yeah. Believe it or not, Doug and I are actually friends outside of this video screen right now. So
Don't admit that, Peter. It could hurt
I
your
won't.
reputation.
I won't.
The end of the day, right? All good people. So are there any other questions of the board for any of the attorneys at this point? Or any, I think should I go back into the audience again as well, Mr. Haverty?
You probably should. I don't anticipate you're going to get any questions.
I will take a moment to be on track. Is anyone that would like to speak in favor or opposition to this administrative appeal? State your name and address, please. Seeing none. If the board does not have any other questions of the attorneys, I would accept the motion to close the public hearing.
I'll make a motion to close the public hearing.
I'll second. This is Mark.
I'm going to poll. Nancy, are you in favor of closing the public hearing?
I am.
Erin, are you in favor of closing the public hearing?
I am.
Jamie, are you in favor of closing the public hearing?
I am.
Mark, are you in favor of closing the public hearing?
I am.
And Steve, are you in favor of closing the public hearing?
I am.
And Brian is also in favor of closing the public hearing. The hearing is closed. I think we all have a pretty good understanding of this. Again, we'll probably be looking for a motion in the affirmative to uphold the decision of the building inspector regarding the tolling timeline.
So I think the decision actually has to be to modify the decision, right? It says
No.
applicant seeks to modify the building inspection decision to determine.
If we're upholding it or we can't modify his decision. We can't do that. We can either uphold it, I believe. I don't know if I can ask Mr. Haverty for.
I'm just
input on
looking
that.
at the agenda. The agenda says applicant seeks to modify the June 19th, 2020 building inspector decision and determine tolling of applicant's special permit and site plan approvals continues until a final judgment in Hyder versus Loop Real Estate, et cetera, et cetera.
That's because they want us to not concur with the building commissioner's decision. So we either uphold the building commissioner's decision and tolling has begun or has ended and the timing has started, or we modify his decision, or we don't concur and tolling continues from the injunction.
You're
Is that
absolutely right.
correct?
We can't modify it.
Right.
We
So
can either.
Tolling has ended.
I see what you're
Don't
saying.
concur and
They're
tolling
seeking to,
continues.
yeah, they're seeking
Right.
to undo it.
Mr. Haverty, would I need to open the public hearing to ask your input on that, or are you allowed to?
I think that your discussion is accurate.
The motion is accurate, you feel? Okay, so the motion would be to uphold the decision of the building inspector. You can disagree with that motion, but I think that's the correct motion we should put forth.
I'm sorry, the determination of the building inspector is that the tolling will continue until a final judgment in that legal case?
No, it's that.
Oh,
No,
it's
it's
the
that it
opposite.
ended. It
Oh,
ended.
okay.
The
It
tolling
ended.
period ended.
When they were
Okay.
told they could come reapply for, they could adjust
Right.
their the building permit.
They were told they could basically move the fence and continue the they were told they could apply for a building permit. That being the case, the fence would have to be in a place that was acceptable to both them and the judge. And then they could move forward with construction. Whether or not COVID happened or there's additional tolling takes place is immaterial to our decision. But the fact
Oh,
of the matter
okay.
is it will continue because of these things. But that isn't our concern or decision. We just have to decide if we're upholding the building inspector's opinion that as of the 11th of September, they were told that they could have a building permit.
If they move the
Do
fence.
it without being on the wrong side of the judge, if you would.
Gotcha. Okay, thank you.
Anybody feel like a motion?
It's a tough one to do. I'll take a shot at it. I'd like to make a motion to uphold the building inspector's decision with regard to tolling of the 12 Kidder Road per special permit and site plan. That tolling period ended when the land court dismissed the appeal of that determination, which was on September 11th, 2019.
I think the tolling stopped when the community development said that they could issue a permit upon they were notified they could issue a permit, that the town could issue a permit because they did not need to file for a substantial modification. It was I forget what they call it.
Minor.
A minor modification.
Try again, Mark.
I made mine, so.
If only we had a lawyer in our
Mr.
midst.
Chairman, if I can try to clarify.
Lawyer on a couch.
There was an appeal filed of the determination made by the planning board. Right? So although the tolling would have ended on that September 22nd hearing, there was an appeal of that determination filed. So there's additional tolling that would still apply. So the motion made by Mr. Carota is correct that tolling period technically ended once the land court dismissed the appeal.
Right.
Okay.
Thank you.
Good job.
Good job.
Somebody paid attention in law school. Wasn't me?
Did you get all that down, Colleen?
I did. I can even reread it.
All right.
I'll second it just to not have to.
Don't have to do anything else, right? We can go to lunch. Okay, I'm going to poll the members.
So we're going by the August 8th, I'm sorry, we're going by the August 8th date when the land court dismissed.
No, part of the motion was September 11th, 2019. Tolling has started.
Correct. Well, actually, tolling period ended.
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 The tolling period ended and the clock started ticking again.
Exactly.
And a vote of yes would be to uphold that decision.
Correct.
And the clock has started ticking again for tolling based on the Superior Court case.
And COVID.
And COVID. Well, that's.
But that's not what the motions, but that's not what this is for.
The Superior Court case started the initial equitable tolling period. The building commission determined that equitable tolling period ended when the planning board made their determination that no additional permitting would be necessary to go and obtain a building permit. There are other tolling periods that would be applicable after that September determination, but you don't need to consider those. All you're considering is the determination made by the building commissioner that initial equitable tolling period stopped at the time that the planning board informed the applicant that they could move forward.
And that's September 11th, 2019.
Correct.
That's right.
Correct.
That's exactly what the motion was.
Clearly.
So, okay, so we're clear. So a vote for yes for this motion would mean that that they can go, that the building commissioner will in effect issue them a building permit if they move the fence. Am I right? Is that what's going to happen?
What we're saying is the clock started ticking again on September
Yeah.
11th. That's really all we're saying.
And there's a certain amount of time out there, right?
Is immaterial. We're agreeing with the finding of the building inspector.
Period.
Okay. It started ticking again. Okay.
Yes.
Okay.
And that's it. All the rest is for others to determine after this.
At a later date. Thank God. Okay, so we have a motion. We have a second by Steve. I'm going to ask Erin, are you in favor of this motion?
Yes.
Jamie? Are you in favor of this motion?
Who all is voting?
Who's voting? I thought
Jamie
you,
is the only one that's not voting.
okay.
I just, I don't know, I'm asking her because she's put in the work. Steve, are you in favor of this motion?
No.
Steve votes no. Nancy, are you in favor of this motion?
No.
Okay, we have 2 no's. Mark, are you in favor of this motion?
Yes.
And I am also in favor of this motion. We have Mark, Brian,
Motion fails.
Erin. It's 3-2, so the motion fails.
Mr. Chairman, it only requires a majority to uphold the determination of the building commissioner.
So there's no supermajority.
No, this is not a special permit or a variance.
Ah, my apologies. So the motion carries.
It was a supermajority.
Hmm?
It passes.
That's correct.
Okay. Well, thank you all for your time.
Thank you. Have
I
a
don't know if
wonderful
anybody's in
weekend.
the mood for minutes or has reviewed them. We can postpone them.
Could we?
Have them,
Unless Nancy's done it all?
I did. I still haven't done February because I wasn't there, so it's on you guys. Use our admin.
February, June, and July.
I looked, I did have a question on July because I know there was the issue with how it was, the legal notice was correct, but the agenda was wrong. And then that carried forward over into it on 2 Merelda Ave. It approves it correctly as a variance, but I think it's a special permit or something like that.
Okay, I'll look at that. That
was my only thought.
Merelda?
The 2 Merelda, Merilda.
I'll go back to that.
That was my only thought.
So you want to correct that before we approve those?
No, I can correct it. We can approve it with that correction.
Okay. Could I have a motion to approve the minutes of 7/9/2020?
I'll do a motion to approve the minutes of 7/9/2020 with that correction.
And can I get a second on that?
I second.
Second by Steve. Mark, are you in favor of the minutes?
Yes.
Jamie, are you in favor of the minutes?
I don't think I was there for those minutes.
Wasn't here.
I can't
Okay.
vote.
Oh, it says you were there.
Well, I got to
July.
correct that too then.
July 9th minutes? Oh, no, I'm sorry. You're under members absent.
Are we doing the next
Sorry.
one? Yeah.
My apologies. No, it doesn't matter. She's under members absent July 9th. My apologies.
I was looking at June
This is
4th.
July.
Yeah.
Okay.
Erin, do you approve the minutes?
Yes, I approve.
And Mark?
Yes, I approve.
Steve?
I approve.
Brian also approves. Does anybody have an
I'll
issue
do
with
it.
February's minutes? Was there changes to be made on that? Nice to get them off the list. We need to read them again.
I checked them. I didn't have anything.
So those are the ones, Nancy had already given me the changes on that, and I did make them.
That was June, because I wasn't at February, I think, so I didn't review those.
I thought it was January.
Was it February? I didn't look at February right now. I know that.
Yeah,
Not
you
this
weren't
one.
at February, right?
February. I think June was the one that we had issues with last time because it wasn't on there that I had recused and.
Yeah.
Yeah, June is still there.
I don't have anything with February.
That sounds like a motion.
I will make a motion to approve the minutes from, oh man,
February
From
6th.
February.
from February 6, 2020.
Oh, yeah, that
Second.
was those two.
I'll second that.
Second by Steve.
No,
That
it's
was
Mark.
Mark.
Oh, I'm sorry.
I
So Steve,
concur.
do you approve of the February minutes?
I approve.
Jamie,
I approve.
Erin,
I approve.
Nancy,
I approve.
Mark,
I approve.
and Brian also approves. So the only ones left are June, and we'll look at those next month.
I did look at them, but
There too?
Is June still, are those the ones, that's the one where I need to have it on there that I recused?
Oh, yeah,
Right? Is that
that's
the
the-
one? 621 Walter Street?
yeah,
There for June.
I fixed that one with the June one. I went back and looked and you recused yourself. It's in there.
Okay. I don't see it. It says, I think it says I'm absent, members absent, and I'm on there. But I was there. I just recused myself at the end.
You were late.
Pretty sure.
Weren't you late?
Yeah, you were late.
No, I
make her
left
ask.
early because I recused myself from the last hearing.
All right, well,
Oh,
Hardy.
okay, so we got two. That's good.
6 to 11 Walter Street. 6 to 11 Walter Street is, yeah. That's the UPS one, right? The UPS,
Yes.
yeah, I recused
Yes, it
myself
is.
from that one. I don't want anything to do with that. Put it in writing. Somebody put it in writing.
So we're gonna approve the minutes now that we understand who was there and who was reclused and who was tardy.
Let me take another look at those because I thought I had fixed all.
Okay, so that's
I
it.
posted the wrong set.
I have a motion to adjourn.
Make a motion to adjourn. Jamie?
Okay, Jamie, Mark, you in favor?
Absolutely.
Nancy, you in favor?
yes.
Oh,
Erin, are you in favor?
Yes.
Jamie,
Yes, sir.
Steve,
Yes.
I'm in favor. Thank you very much for your time tonight.
Thank you for
Good
indulging me
work.
everyone with all the easy questions.
It was tough. It was hard to figure it all out, but I think we
It
took
was-
the time and did it right. Good night, everyone.